Welcome to CLE Cast. I'm Rachel, and this is a 30-minute professional rules of conduct continuing legal education video. In this video, we will cover some important professionalism topics such as credibility, interacting with the court and colleagues, supervising non-lawyers in the firm, and witness preparation. Please check your bar website to see if this video has been approved for CLE credit. The CLE Cast website, which is clecast.net, lists the bar jurisdictions that we understand to have approved this video for credit. But, as always, we cannot guarantee how up-to-date that list is, so please double-check with your bar. Additionally, there will be some keywords given periodically in the video should your bar require proof that you watched the video in full through keywords. Please subscribe to this YouTube channel to support CLE Cast and get updates when new videos are posted. Our website, clecast.net, has other continuing legal education videos available for purchase. Half the proceeds of purchased CLE videos are donated to nonprofits. Additionally, check the website for information on where to access your bar's ethics codes for reference. This video is using the American Bar Association Model Rules of Professional Conduct. The ABA Model Rules of Professional Conduct serve as the ethics rules for most jurisdictions because they did adopt them, but some jurisdictions have also made some modifications to the rules. Now, let's get started on our CLE. Ethics is a word that has been traditionally used in the legal profession to describe how lawyers are required to conduct themselves. They are based on a set of rules called the Model Rules of Professional Conduct, which you must follow. These rules set out how you should conduct yourself while practicing law and representing clients. So if the rule says you must do something, you should do it. If the rule says not to do something, you should refrain from doing so. Failing to follow the rules of professional conduct can result in sanctions as well as negative impact to your reputation in the legal field. I recall starting as a new attorney and having others explain that the first thing that they did when receiving the monthly bar bulletin was to flip directly to the back where the sanctions section listed who had been reported and how their case was handled, whether it was just sanctions, a warning, maybe disbarment. You may find that people use the word ethics interchangeably with the phrase rules of professional conduct. The rules are a standard, and in many cases, they are the low bar, but others in the legal field may expect more from you because they hold even higher standards for themselves and other attorneys than are prescribed by the rules. The professional rules of conduct are enforced. The bar enforces them. But most importantly, they are also enforced by your peers. Others in the legal field may decide to report rule violations for the bar to investigate and determine if sanctions are appropriate. Importantly, though, your conduct impacts how lawyers and judges will interact with you moving forward, which can positively or negatively impact your legal practice and ability to be effective in your work. So, remember that your reputation is extremely important in this field. Your credibility with others will make a difference in what you can accomplish, if you get referrals from other members of the bar, and more. Think of this like you would a firm or a company culture. They can put out all the marketing and statements about their values and their company culture that they like. But if their actions do not match those words, it doesn't matter. People remember and talk about how the company functions, how the people who work there act, and so forth. An extension of this is how the court views you, how a judge treats you because of your reputation and previous actions in the court. It can go a long way when you hit a snag or make a mistake to already have the court's respect, because they will be more likely to assume the best of you in the situation. You will hopefully be able to steer out of the problem a little bit easier and slightly less scathed because of that good reputation. Now, let's go over some professional conduct rules a little bit more specifically. Model Rule of Professional Conduct 3.4 outlines rules of conduct for lawyers. As with rules mentioned in this video moving forward, the rule will appear on the screen. Rule 3.4 tells us that you cannot unlawfully obstruct another party's access to evidence. You cannot unlawfully alter, destroy, or conceal items that have evidentiary value. Falsifying evidence or having others do so is prohibited. That creates an unfair playing field and negatively impacts the ability of the judicial system to function in a fair and impartial manner. The same goes for knowingly disobeying an obligation or the tribunal's rules, creating frivolous motions or requests, alluding to matters at trial that you do not have a reasonable belief is relevant and admissible. These aren't just rules to follow, but disobeying them is a quick way to irritate opposing counsel and perhaps even more so the judge in the case. Rule 3.3 explains the expectations and how you will treat the court or tribunal. A lawyer is prohibited from making a false statement knowingly, and so there is also an expectation that when an attorney learns a statement or material fact of law has been made incorrectly, it must be corrected by the lawyer. So essentially, inform the court once you are aware that you have made a materially false statement. Similarly, don't offer evidence you know to be false, and correct the record if you later learn that the evidence that was offered turned out to be false. You are further prohibited from offering false statements about what the law says, and you are required to disclose legal authority that you know to be directly adverse to your client is from your controlling jurisdiction and has not been disclosed by opposing counsel. These rules are meant to ensure the court is able to make rulings and conduct the proceedings based on the law and the truth. There have been some entertaining moments with technology in the legal field. Some most memorable Zoom moments, like toilets flushing during hearings and I am not a cat declarations when an attorney did not know how to turn off a filter. You may recall the recent news involving attorneys using AI or ChatGPT to write legal briefs, which were submitted to the court. The court was extremely unhappy and issued sanctions because the attorneys did not ensure that the ChatGPT generated information was actually correct. Let's look at this a little bit more closely. Attorneys at the Levidow firm submitted filings to the court without checking that the citations and the law were in fact real and accurate. Thus, they abandoned their responsibility to act as gatekeepers who ensure accuracy of the information in the court record. Then, when the accuracy of the ChatGPT generated information was questioned by the court, the attorneys stood by them. The court explains that this creates harms like wasting time and money of the opposing party, who had to then work on exposing the issue, wasting the court's time, which could have been focused on other important work, depriving clients of judicially sound arguments, and damage the judges and courts who may end up creating decisions based on these false legal writings. All this can lead to a lack of trust in the legal system and more people defying the court rules, possibly even defying court rulings because the court's authenticity is called into doubt. Could this have been avoided by checking citations and work prior to the filings? Yes. Could further damage have been avoided if the Levidow firm attorneys had taken seriously the filings about case law not being real and accurate? Yes, they absolutely should have determined the veracity of the statements that they made and then reported themselves to the court. Instead, they doubled down. In its 2023 opinion and order on sanctions, the judge discusses the federal rules of procedure and case law that creates rules and guidance in these types of circumstances. The court also specified Rule 3.3 of the New York Rules of Professional Conduct, which mirrors the ABA Rule 3.3. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. The court ordered sanctions here, and the bar can consider further proceedings. Best practice for ensuring that you are not violating these rules and still giving your client the best advocacy possible are to discuss it ahead of time. Find a trusted colleague who can give advice. Call a resource your jurisdiction's bar offers for attorneys to discuss ethics matters. Bring the issue to the judge's attention. Generally, judges appreciate when people bring mistakes to their attention so that corrections can be made with as little headache as possible. A mea culpa can be embarrassing, however, it is less invasive, less time-consuming, and less embarrassing than the hearings and proceedings that the Levidow firm attorneys endured. The first key word in this CLE is tulip, T-U-L-I-P, tulip. But what if it was a paralegal in the firm who submitted the improper information to the court? Rules 5.1, 5.2, and 5.3 specify the responsibilities of supervisors, subordinates, and overseeing the work of a non-lawyer in the firm. According to Rule 5.1, those with managerial or supervisory authority in a firm must make reasonable efforts to ensure lawyers are conforming with the rules of professional conduct. If that doesn't happen, you can be held responsible for the other person's violation of the rules. In a firm, there are often non-lawyers assisting with the work. Rule 5.3 addresses possible issues here. Supervisors and those in managerial roles have an obligation to ensure the rules of professional conduct are followed by non-lawyers in the firm, and this includes training and oversight. If this isn't done, the lawyer can be considered in violation of the model rules. The ABA Standing Committee on Ethics and Professional Responsibility issued a formal opinion number 506 on June 7, 2023 about responsibilities regarding non-lawyer assistance. Support staff provide all sorts of services within a firm, but it's important that their work remains within the rules of professional conduct. Attorneys can train and supervise non-lawyers in work like prospective client intake, where the non-lawyer is gathering initial information about the matter, doing a conflict check, determining whether the client needs assistance in an area that the attorney or the law firm actually practices in, explaining how the fee structure would work at the firm if the firm represented the client, and getting appropriate paperwork signed. These are all things that are fine, but bear in mind that with fee structure and scope of work decisions, the client must be given the opportunity to discuss these details with the attorney. This ties into Rule 5.5. Now, with Rule 5.5 prohibiting attorneys from assisting with the unauthorized practice of law, how these types of conversations with a non-lawyer employee can be structured is important to supervise. Specific questions around things like what the scope of work should look like, fee negotiations, interpretation of the agreement, and things like that is something that the lawyer should engage in, not the non-lawyer employee without a bar license. Otherwise, the employee could be found to be engaging in the practice of law in violation of Rule 5.5. It would be a violation of Rule 5.32, since the attorney must ensure that they are supervising people to adhere to the rules of professional conduct. Remember, the Rule 5.3 language is about the fact that you must make reasonable efforts or give appropriate instruction and supervision around the ethical aspects of working at the firm. So delegate, but instruct and supervise appropriately. When we are talking about establishing a client-lawyer relationship, it's important to remember Rule 1.5b, which states, the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client, preferably in writing, before or within a reasonable time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis or rate. Any changes in the basis or rate of the fee or expenses shall also be communicated to the client. Discussion of the actual scope of representation, the client's objectives, and what actions the lawyer can and will take needs to occur between the lawyer and the client, not with support staff. Details about the basis of fees and expenses that will be charged to the client must be determined between the lawyer and the client. This also intersects with Rule 1.4b, which requires reasonable communication with the client, which includes explanations of the situation and legal options that sufficiently allow the client to make informed decisions about their representation. Shifting now to witness preparation and Model Rule 3.4b, a lawyer shall not falsify evidence, counsel or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. The American Bar Association issued Formal Opinion 508 on August 5, 2023 on this topic. The opinion notes that witness preparation for testimony is an essential function of a lawyer's advocacy. In fact, under the model rules, an attorney's duty to serve as an advisor dictates that adequate witness preparation is an essential function, and failure to do so could be classified as an ethical violation. The line is clearly crossed when a lawyer tells the witness to give false testimony or assist them in doing so. Certain behaviors, advice, or actions are established as unethical because they would interfere with the integrity of the justice system. Rules that are applicable are Rules 1.2, 3.3, 3.4, 4.4, and 8.4. Rule 1.2d says, a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. Rule 3.3, you'll recall, requires candor toward the tribunal, and Rule 3.4 requires fairness towards the opposing party and counsel. Rule 4.4 says, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. And a lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client and knows or reasonably should know that the document or electronically stored information was inadvertently sent shall promptly notify the sender. And 8.4 covers misconduct. So, when speaking with your client about their testimony, it is appropriate and ethical to discuss what will be said and what cannot be said due to legal rules. The ABA is clear that the following are activities you can engage in and are important to engage in to ensure thoroughness and preparation. Remind the witness that they will be under oath. Emphasize the importance of telling the truth. Explain that telling the truth can include a truthful answer of, I do not recall. Explain the case strategy and procedure, including the nature of the testimonial process or the purpose of the deposition. Suggest proper attire and appropriate demeanor and decorum. Provide context for the witness's testimony. Inquire into the witness's probable testimony and recollection. Identify other testimony that is expected to be present and explore the witness's version of events in light of that testimony. Review documents or physical evidence with the witness, including using documents to refresh a witness's recollection of the facts. Identify lines of questioning and potential cross-examination. Suggest choice of words that might be employed to make the witness's meaning clear. Tell the witness not to answer a question until it has been completely asked. Emphasize the importance of remaining calm and not arguing with the questioning lawyer. Tell the witness to testify only about what they know and remember and not to guess or speculate. Familiarize the witness with the idea of focusing on answering the question, i.e., not volunteering information. This preparatory work is covered by Model Rule 1.1, which states a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. This rule is important to ensuring the public can trust the legal system is working as expected. It's a core ethical duty to perform your work with competence, meaning that you have to maintain a minimum level of ability, exhibiting the necessary amounts of legal skill, knowledge, thoroughness, and preparation needed for the case or issue at hand. So we know there are certain things that the model rules and ABA encourage an attorney to do in preparing a witness to testify. Let's look a bit at the line that shouldn't be crossed. It's not okay to improperly influence the testimony through manipulative conduct during preparation or attempts to interfere or influence what is said during the testimony. Formal Opinion 508 gives a very clear directive. Within the broad class of lawyer conduct directed at a client's or witness's future testimony, certain categories of lawyer activity are firmly established as unethically interfering with the integrity of the justice system and unethically obstructing another party's access to evidence. A lawyer violates ethical obligations by counseling a witness to give false testimony, assisting a witness in offering false testimony, advising a client or a witness to disobey a court order regulating discovery or trial process, offering an unlawful inducement to a witness, or procuring a witness's absence from a proceeding. Please note that helping a witness lie isn't just an outright instruction to do so, but it can also be instructing a witness to downplay something, like the numbers of times that they have met with their lawyer to prepare for trial, to encourage a client to misrepresent a location in order to have a viable claim, programming, scripting, or over-directing how a witness should testify so that it tampers with the heart of the testimony, encouraging fabricated testimony be given, violating a court sequestration order, compensating a lay witness for the testimony or making a payment conditional upon the content of the testimony. And note here that this is even if the condition is for truthful testimony. This is still an attempt to influence a testimony, and it's improper even if the promise is something else, like to donate to the witness's favorite nonprofit or charity. Offering money for someone to not testify is considered tampering and also prohibited. Additionally, an attorney should not attempt to manipulate testimony while it is in progress, because it can be prejudicial to the administration of justice, which Rule 8.4d considers professional misconduct for a lawyer. Examples of mid-testimony efforts to improperly influence in-progress testimony are passing a note or whispering to the witness, creating a speaking or suggestive objection. Additional areas of concern for misconduct are available because of technology. Remote communication platforms are used in proceedings and depositions more and more frequently now, but they also can then create an easier avenue for the attorney to surreptitiously influence the witness testimony inappropriately. Sending messages through technology to coach or give specific directions on how to respond to a question is not allowed, whether it's with a cell phone or other messaging equipment in that video platform. An Arizona lawyer was suspended for using a chat feature to instruct a client during cross-examination at trial using a web conferencing software program. So beware, it is taken seriously. Now, make sure you are adequately preparing your witness, but don't cross lines into manipulating or overly influencing the witness's testimony either before or during the testimony. The second keyword for this video is MAPLE, M-A-P-L-E, MAPLE. The last topic we will cover today is communications with represented opponents. Under ABA Model Rule 4.2, a lawyer cannot communicate with or cause another to communicate about the subject of the representation with someone known to be represented in the matter. There is an exception for when the represented party's attorney has given consent for the communication. The rule talks about persons and means persons, parties, opponents, third parties brought into the litigation by formal process, and witnesses. Represented non-lawyer clients can communicate with each other. They aren't restricted by this rule. An attorney cannot try and get around this, though, by sending their client to talk with the opposing or represented party. That would be a violation of Rule 8.4a, which says it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. Recently, some guidance on how a lawyer can navigate assisting a client with client-to-client communications was issued in the DC Bar Legal Ethics Committee Opinion 385. While the lawyer can't participate, listen to, or coach a client in real time for these client-to-client communications, an attorney can give advice in some limited scenarios. This is a gray area, so be cautious. Sometimes a party-to-party communication can help the client reach their objectives, and it's okay to answer questions about that and assist with the client's preparation for these communications, as long as the attorney is not dictating or directing the communications and not coaching the client to seek confidential communication, to seek confidential information, admissions, or binding agreements. The lawyer may, however, do the following: solicit and clarify the client's objectives for the communication or meeting, remind the client of previously stated objectives in the litigation and propose objectives for the communication or meeting, assist the client in drafting talking points or questions to present during the meeting, advise the client on how the client should respond to information or questions that the opponent party may present during the meeting. The lawyer may not, however, attempt to script the communication or coach the client to handle the communications as the lawyer would. The point of encouraging the parties to speak directly to one another is to use the dynamics between them and their own voices to find common ground. When the lawyer's level of assistance in preparing for these communications turns the client into the lawyer's surrogate, it has gone too far. If the client-to-client communication results in agreement on how to settle the dispute, counsel can assist the client in getting that agreement into writing. Also, make sure that you advise your client that they cannot harass the other party, and the other party may want to consult with their attorney about aspects of the conversation like agreements or admissions, and these communications with their lawyers should be encouraged. Also, make sure your client understands that you cannot attend or observe these party-to-party communications, nor can you assist them during them. So that real-time assistance that can be provided in text messages or virtual meeting chats is just not allowed. And with that, we will close out this ABA Rules of Professional Conduct CLE. I hope that this explanation of some of the ethics rules was useful and that you can use it for your CLE reporting requirements. Again, I encourage you to check with your bar for whether or not this video has been approved. Please check our website, clecast.net, for further materials and more CLEs. And subscribe to this YouTube channel for future CLE videos. Thank you for your time, and I'll see you again soon.